What a good question. And just to say, I always feel I'm learning. So it'll be great in terms of these conversations and where we go. I'm increasingly concerned about us using voice to encapsulate kind of where we want to get to. I know it's a powerful term in civic society and we use it, but just at a very basic level, I think however much you put it into quotes, it does risk privileging certain types of communication. And I remember reading this really powerful article, I believe by a Finnish researcher working with disabled children. And she responded quite strongly to that, and the children responded quite strongly to that being a disableist point of view. So like, why would we use a term that might risk that? I mean, getting a little bit more conceptual with it, also kind of concerned, particularly when we use it in the singular, because why would we expect all children to have the same voice? So obviously we could plural. I still have a few further problems with it. Often, in very well-meaning ways, when we're working with children and we present the voice of the child, usually somebody has selected what that is, and it's often not the children who selected. And the last bit that worries me about it is really from our experience in terms of family law. There's a convenience for adults if you think you have the voice of the child, that it's the authentic, and often that's how it's phrased, the authentic voice of the child. And as you may know, when there's contested cases in family law in Scotland, there is a requirement for courts to consider children's views. And often what they do is they ask what is now called the child welfare reporter to go and access the child's views and present them in the report. And you can see how actually that's quite convenient for the court, because then they have the view of the voice of the child, and they can hopefully enter that into decision making. But when we're doing research with children and looking at that, it has real problems. So it's really notable that courts tend to take more consideration of a child's views expressed in that way if it's perceived as rational, unchanging, and autonomous, like it actually has to be independent. But that raises all kinds of issues that we're talking about with the courts because of what children tell us, right? Like, why would your view always be sort of set, months in advance of the court meeting? Why wouldn't it be emotional and relational? So I think the challenge for us, I suggest, is to be able to incorporate all that kind of complexity. And that applies to younger children as well as older children. And actually it is often younger children who are involved in family law cases. I think it's useful for us to remember that there's a range of participation rights in the UNCRC that we need to consider, that views is only one, and it's quite tied in Article 12 in terms of decision making. So I think that's very valuable, but I also think this is an opportunity for us to think of participation widely. It's also about involvement, about engagement, activism, feelings, and I think that's something that all of those, like yourself, Carmel, who really are experienced about working with young children, can really bring to the table.